Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? On July 31st, 2024, Massachusetts joined other states in mandating pay transparency by requiring pay range information in all job postings and advertisements for employers with more than 25 employees. The disclosure requirements will commence on October 29, 2025, 1 year after the effective date of the law. On this episode of We Get Work, we discuss the Massachusetts Pay Transparency Law, wage data reporting requirements, the law's no retaliation provision, and why employers should start preparing now for the changes to come. Our hosts today are Matt Camardella, principal and co-leader of the Affirmative Action, OFCCP, and Government Contract Compliance Group, and a principal in the Long Island office of Jackson Lewis, and Brian Lewis, a principal in the firm's Boston office. Matt and Brian, the question on everyone's mind today is, what must employers do to prepare for and comply with the new Massachusetts law, and how does that impact my business?
Welcome, everyone. It's a pleasure to have the opportunity to speak to you all about Massachusetts' new pay transparency law. My name is Matt Camardella. I'm a principal here at Jackson Lewis and a member of the firm's Pay Equity Resource Group. I have the pleasure today of speaking with my fellow principal, Brian Lewis, who is resident in our Boston office, about the requirements of this new law. So Brian, like many states who have taken steps to help address the stubborn gender and racial wage gaps in this country, Massachusetts recently enacted a statute aimed at enhancing pay transparency. The name of this new law, an act relative to salary range transparency, they really need to come up with a better name for this statute. Massachusetts has jumped on the pay transparency bandwagon. Coupled with the Massachusetts Equal Pay Act, the state is at the forefront of the battle against pay inequality. Okay, so let's jump in. Brian, Governor Healy signed this bill into law on July 31st, 2024. From my initial review of the statute, it appears there are two main requirements here. Can you tell us what they are?
Sure, Matt, and thanks for having me on. I'm looking forward to talking about this with you during this podcast. As you indicate, there are two primary requirements here under the law. One is a disclosure of pay ranges, which basically specifically means when companies or employers are posting positions, the employers are going to be required to disclose the annual salary range or the hourly wage range that the employer reasonably and in good faith expects to pay for the position. So that's the disclosure of pay range. And that's a traditional pay transparency law that we've been seeing across the country in a number of states. And as you said, Massachusetts is now just sort of jumping on the bandwagon. I should note when we talk about this, not only does these salary range postings are required to be done for applicants, they're also required to be done when a company is posting for a promotion or a transfer within the organization. Or for that matter, even if an employee at a company simply wants to know the information, they are allowed to ask about the salary range for their own job position in the company. So it's more expansive than just posting for applications. So that's the first piece, this disclosure of pay ranges. The second piece is a little more unusual, and I'm sure I know you're going to talk a little bit about it later in the podcast, but there's also now going to be a requirement for employers in Massachusetts to report wage data to the state. This is a little unique, and these are reports that are EEO1 type reports, EEO4 type reports, and I know in your practice you spend a lot of time with this, so we'll talk a little bit about that later.
Yep, I sure do, and happy to chat about it a little bit later on. So two main sets of requirements here under the law. Does this law apply to all employers in Massachusetts?
So luckily, no. It only applies to larger employers. Under these requirements, under the statute, employers that are covered are only those employers that employ 25 or more employees in the state of Massachusetts or in the Commonwealth of Massachusetts. That's actually a really important distinction because a lot of times the law doesn't give us that information, but this law does. And that's important because now an out-of-state company or an out-of-state employer that has a minimal presence in Massachusetts is not covered by the law. Simply having employees in Massachusetts doesn't make you covered. You need to have 25 or more. At the same time, the way this law is written, advertising for a position via a website or Indeed or one of those job aggregator sites that a Massachusetts applicant will see doesn't implicate the Massachusetts law unless that company has 25 employees in the state. So it is limited in that way, which I think is really helpful to know.
For sure. And somewhat different from some of the other state laws out there. And I believe there's even a higher threshold for the wage reporting piece, if memory serves. Was that 100 or more employees?
It is. It's the folks. It's the wage reporting piece, and you'll talk a little bit about this later. Is the same requirement that employees have to report the federal data. It's the same coverage requirement. Of course, we should also note, even if you're posting these jobs on websites or externally, there's certainly other state wage transparency laws that may apply, even though you don't necessarily have to worry about the Massachusetts one. There's always, unfortunately, that patchwork of laws that we're dealing with here.
Gotcha. Okay. So, Brian, I'm sure some companies will struggle with this, and there'll probably be some companies who either are unaware or ignore it. So, what are the penalties for non-compliance? And is there, importantly, a private right of action under this law?
Right. So when we talk about private right of action, you mean, can someone get sued? Can a company be sued by a disgruntled applicant or employee for failing to comply with this law? And the answer to that question is no, they can't. There is no private right of action under the Massachusetts law. The enforcement powers under the Massachusetts law for these salary postings is solely found within the Massachusetts Attorney General's office. Now, I don't know if that's a good thing or a bad thing. We deal with the Massachusetts Attorney General's office a lot of times, and they're a very aggressive agency, and they take a lot of actions to protect employee rights. And sometimes I would suspect some employers would indicate that they're a tough agency to deal with. But they're the ones that have the exclusive right to enforce it. At the same time, the law limits exactly how they can enforce this and gives a little bit of protection for companies that screw up once or twice or mess up once or twice. The Attorney General is allowed to issue fines for these types of noncompliance, but for the first violation, they're only allowed to give a warning. They can't issue a fine. The second violation, they can issue a $500 fine. The third violation, they can issue a $1,000 fine. Once you get to the fourth violation, if you're going to get there, the fines go up very substantially and can be up to $25,000. But for the first couple times, the Attorney General's office recognizes that people are going to try to struggle with this law, and they're really going to try to get people into compliance before they really hit them with fines.
All right. Well, Brian, let's hope we're not helping any employers who are up to their fourth offense or higher. All right.
Sure.
So one of the other things that we see in many of this wave of pay transparency laws out there amongst the states are protections for employees or applicants. Are there any protections available to employees or applicants who want to inquire or make, ask questions about pay ranges?
So that's a really good question, and that's a really important question and an important distinction. Because when I said before that the Attorney General's office is the exclusive agency that enforces the law, and there's no private right of action, that only applies to the actual posting of the laws. Posting of the job ranges. For employees or applicants that are asking or wanting to see their wages or wanting to see the salary ranges within the job they're applying for, there are very strong anti-retaliation provisions there in which companies can't retaliate against someone for asking for the information. With that, just so you know, there is a private right of action. A disgruntled employee or an applicant can bring a suit against the company for that violation. And if they bring that type of action, there's enhanced damages to that, which are greater than the fines that we just talked about. So you have to be very careful about not retaliating against employees or applicants who want to ask for this information because they will now have a right to get it.
All right, I'm following. So if I were an applicant, for example, who inquired into the salary range for a particular job I was interested in, and I did not get that job, presumably I could bring a claim alleging that the reason I wasn't hired was because I inquired into what the job would pay, and assuming I could prove it, I'd be entitled to some sort of damages in a private right of action.
Sure, right. So that's important for the company addressing these laws, as it's important today and going forward, to make sure their decisions on applicants are made for the right reasons and they're not made for unlawful reasons, and they're not making a decision saying, oh, Matt asked us questions about the salary, we're not going to hire him, we're not going to move forward with him, because would be an unlawful action when this law kicks into effect.
Yeah. Okay, that makes sense. Brian, you've explained quite a bit, but there must be some unanswered questions in this law. So from your perspective, what items would you like more clarification on?
Yeah, there's always some holes or some questions we have when we have new legislation that's put in place. A couple things that just come to mind right away for me are questions like, does this law apply for a Massachusetts employer that is looking for people in locations outside of Massachusetts? Let's say a Massachusetts employer has an office in Florida or an office in Kansas. Does the law apply for those applications? That's sort of an unanswered question, unfortunately, right now. What if a Massachusetts employer? Another question is, what if a Massachusetts employer is applying for or looking for people for hybrid work? That they don't have to work in Massachusetts, they can work anywhere. They can work in Hawaii, they can work in Puerto Rico, they can work in what have you. There's not clarity, at least now, about how far that law extends.
Those are good questions. I don't know that I thought of all those. So do we expect any additional guidance or clarification from the state on what the law means and how it applies?
So a couple things to remember when we're thinking about this. Number one, the law is not kicking into effect for a year. When it was passed, it is not going to become effective until October 2025. So companies and employers have at least a year to prepare for and get ready for this law. The law also says that the Attorney General's office, because again, I mentioned the enforcement agency here, is required to engage in what's called a public awareness campaign within the next 6 months. Don't know what that means, but we shall see. Right? I don't know if that's going to mean they're going to issue regulations, if they're going to issue guidance on their website. In the past, the Attorney General's office has done that. We just don't know exactly what they're going to do now.
Gotcha. Okay. Brian, all very helpful. So here's a question that I know many employers are struggling with. As we mentioned at the top and throughout so far, several states have passed laws requiring the posting of pay ranges with job openings. Should an employer adhere to a single practice of listing salary ranges in all their job postings selectively? What are your thoughts on that?
Yeah, we get that question a lot, as you can imagine, when this patchwork of laws and these different state laws continues to grow and continues to grow and grow and grow for these multi-state employers. I'll give the classic lawyer's answer. It depends, right? Each company is going to have to analyze this specifically and how it affects their company. Is the company operating largely in jurisdictions like Massachusetts and others that have these requirements? Is its workforce remote? There's more companies that have really a dispersed workforce now that's all across the country, frankly, all across the globe. If they decided to post these salary ranges now or to be upfront about these laws, will that impact employee relations issues? These are all questions that I can't answer, but companies are going to have to think about when they're trying to determine this sort of one-size-fits-all approach.
Good info.
Yeah. So, well, hopefully I've given you a little bit of information about this law as we're trying to digest it here in Massachusetts. But I do want to sort of now ask you some questions, if you don't mind.
Wait a second. I was told I'd be asking the questions on this.
I know. We're flipping it a little bit here.
Okay.
But this is actually really important because, as we talked about before, in addition to the salary posting and the wage posting, there are these wage reporting requirements. And I know you spend a lot of time talking to contractors and other companies about wage reporting requirements. So, would being a government contractor impact how a company may look at this law and try to deal with this law?
The short answer is yes, and the reason is because the Federal Acquisition Regulation Council, which is the federal agency responsible for creating all types of terms and conditions in federal contracts. So when a business, for example, wants to sell goods or services to the federal government and one of its agencies, they adhere to certain sets of terms and conditions in their contracts. It's the FAR Council that establishes all those. And they recently proposed requiring federal government contractors to post the salary ranges for all positions that are working on or sufficiently related to the fulfillment of a federal contract. So assuming that this proposed rule becomes finalized and becomes a standard term and condition in federal government contracts, this is really going to push the federal government contractor community towards adopting a uniform policy when it comes to whether or not to post salary ranges with their job openings, right? That way they don't have to individually assess whether or not they're subject to a requirement in a particular jurisdiction for a particular job opening, and would be much easier to administer for their HR and talent acquisition staffs, and avoid just a patchwork of different approaches depending upon the job and its location.
Yeah, that's really insightful and helpful information to think about that for the contractor community. As I mentioned before, the other piece of this, the Massachusetts law, is this wage reporting requirements. And I'm familiar with the idea that these are very similar. They seem very similar to those EEOC requirements that I know there's been a lot of discussion of over the past 10 years. Am I wrong? I mean, is this similar to what the EEOC is sort of asking companies to do?
Yeah, you're not wrong. If you feel like you're reliving a nightmare, you're not. So you may remember a few years back that the EEOC, in fact, was requiring employers, as part of their annual EEO1 reporting requirements, to report not just on the race and gender of its employee populations, but also wage data. What was called Component 2 of the EO1 report. That was short-lived. It only lasted for 2 years, and it was rescinded during the Trump administration. It's also similar, frankly, to what California and Illinois are already requiring of employers in their states. But recently, the EEOC, which is now controlled by a majority of democratically appointed members, has been talking about resuscitating Component 2. And while it may look somewhat different and take a slightly different form, we're anticipating that the new iteration of Component 2 will similarly ask for some sort of annual reporting of wage data broken down by race and gender demographics in different categories. But at the same time, Brian, there is an election coming up, as you know, and the outcome certainly could impact the direction the EEOC follows here.
Well, this sounds like this is just more regulation and more burden on companies. How much of a burden do you think this will be for companies in Massachusetts with this new, at least state law that they're dealing with?
Sure. Well, look, it won't be insignificant, but I think at the end of the day, the burden is really going to depend on the size of the employer and how robust their systems are. Right? If wage data can't be easily queried out of their HRIS, you can imagine what a nightmare it might be if they have to pull individual payroll records for hundreds of employees at a time.
Sure. And another question that came up, Matt, is once the employers submit this data to the state, what's going to happen to it? Do we know what's going to happen to it? Is it going to be available publicly? Do we know?
Yeah, the law is actually pretty explicit, and it does seem that is going to be made available. The law speaks to publicly sharing on a state website aggregated data by industry. However, it also appears that the individual employer data will not be made available to the public. Moreover, there's a provision in the law that exempts this data explicitly from being deemed a public record that could be requested by the public as part of a request for information.
Oh, that's really good news. And that's I'm sure a lot of companies are going to be happy to hear that their data is not going to be splayed across the internet for all to see. So with all this data that these companies are gathering and pulling together and reporting, What should they be doing with this data? Should they be trying to address these issues proactively?
Yeah, well, look, that's our strong recommendation, Brian, and it has been for some time. As you know, Massachusetts already has one of the strongest pay equity laws in the country, making it easier to bring claims of pay discrimination and harder for employers to defend them. On the bright side, though, MEPA, as the law is known, does provide a safe harbor for employers who undertake their own pay equity analysis. Specifically, what the law allows is for employers to assert an affirmative defense to a claim of pay discrimination if they undertook a reasonable analysis within the last 3 years and either remedied the issues or didn't identify any. Right? So that protection, coupled with the fact that many employers in the state of Massachusetts are now going to have to report their wage data to the government, really is a strong incentive for an employer to perform some sort of pay evaluation, pay equity analysis. But look, a word to the wise here, as with any self-critical analysis, something that could be used against you should it become a matter of public record, employers should really undertake every effort to do this type of analysis under the direction of counsel to help maintain a privilege and prevent it from being discoverable by either the state, the federal government, or private litigants.
Yeah, from personal experience, I know a number of companies have undertaken this type of analysis, pay equity analysis over the past 5 years or so, and found really helpful information when they've done it. Either way, like you said, either number one, they have some issues they need to address, or number two, it just reinforces the fact that they are doing things well and doing things the right way regarding pay equity. So yeah. I completely concur with the idea of a pay equity analysis, and if you can, under the guise of an attorney-client privilege. So
couldn't agree more.
Yeah. So this is all very helpful, Matt. I really do appreciate you sort of spending a little bit of time talking with me about this new law and what we recommend for companies and employers to do.
Well, Brian, it was great chatting with you as well. Thanks for sharing your insights. And I think that pretty much is all the time we have today. So I hope we can do this again soon.
Me too. Thanks so much.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.